Mr. Berman?
Do I misunderstand the record here that the Superior Court case was dismissed in June of 05? Is that right?
Yes, I believe that that's correct, Your Honor.
And the petition in this court was not filed until September of 06?
That's correct, Your Honor.
Why is that?
That's a mystery to us as well. You'll see in my client's affidavits that they were not aware of the alternative of filing a petition with this court under Section 10.
Mr. Berman,
yes, ma'am.
Don't we have here what in other circumstances would be attorney malpractice?
Well,
and aren't there,
clearly attorney malpractice.
And aren't there remedies for that?
Well, there are, but as Judge Gertner indicated in the Mullins decision, Your Honor, that should not be irrelevant. And I understand that it's not, this court does not consider that to be any type of precedent whatsoever, but it is a well-reasoned decision. To make that a factor in whether...
No, but statute of, I mean, they're, you know, statute of limitations, that's what you learn. It's what I teach. It's whatever, you know, as soon as you are consulted, start running that statute of limitations. And for an attorney to say, I was confused, and then now it appears that the attorney was also confused about the availability of an alternative remedy, when the one thing that we know about it, the wrapping up of the states, is that the legislature has tried to make as plain as it possibly can. 1 year is a short limitations period, because you can't have people sort of being, you know, waiting for years and years and years until the estate is wrapped up.
Agreed, Your Honor. I think in consideration of the short statute of limitations contained in Section 9, the legislature put into place Section 10.
But the legislature didn't put in place Section 10 to take care of attorney malpractice. Well, I mean, it might have taken care of, you know, the mail didn't function. I mean, this seems to me very different from the other cases.
I think this theory, if we adopt your theory and say that the attorney's misunderstanding of the 1 year statute of limitations was within the range of ordinary excusable fallibility and it isn't attributable to the client, then wouldn't that apply to insulate most plaintiffs from delayed claims and in effect eradicate the 1 year statute of limitations in Section 9?
Well, I don't think it would eradicate the 1 year statute of limitations. I think that what would happen if your court were to consider the potential legal malpractice claim, that would eradicate Section 10, because essentially every case of this nature involves some attorney who didn't abide by the 1 year statute of limitations. In every case that an attorney was involved and Section 9 was not complied with, that leads to a negligence malpractice case against that attorney. And to rule in that manner would consume Section 10 petitions.
But isn't Section 10 for special situations, not an ordinary situation, which is apparently what this is?
Well, it's for situations, as stated repeatedly in the case law, where the conduct of the attorney doesn't rise to the level of culpable neglect that can be attributable to the client. Now, the definition of what's normal negligence that cannot be attributable to the client is, as stated in the case law, inadvertence, misunderstanding of the law, which is precisely what Mrs. Zanadakis, did in this case. That's uncontroverted in the record. She stated that she wasn't aware that the 1 year statute applied. And moreover, and more importantly, I would suggest to Your Honors, my clients were not aware of a 1 year statute of limitations.
Yeah, but that's why you have attorneys. I mean, it seems, again, I'm just repeating myself, but it seems to me that the one thing that is clear, I mean, one thing is clear, statute of limitations, and as Mr. Musia pointed out, here you don't have any knew or should have known where there might have been iffy. You have a decedent's death. Clearly,
Your Honor. But the issue here under Section 10 and under the case law interpreting Section 10 is not just whether or not the attorney was negligent. It looks at the relationship between the creditors and the estate.
Well,
and there is, I'm sorry, Your Honor, and there is some consideration as to whether or not the creditors should be held accountable for the actions of the attorney. And that involves a determination of whether there's a meritorious claim and whether justice and equity require maintenance of the claim, and whether or not the culpable neglect, which is something more than mere inadvertence, can be attributable to the clients. And you see cases like Leach and Monaghan where the plaintiffs themselves were involved in a decision not to pursue a Section 10 or not to pursue a Section 9 claim against the estate. Those are the situations in which creditors should be precluded from pursuing the claim.
May I just ask you this? I suppose it's already been asked, but I'm just kind of puzzling over this. If we agree with your position, doesn't it mean that whenever there's a statute of limitations, that a lawyer could say they misunderstood it? And wouldn't it, if we agree with you in this case, wouldn't we have to always agree that a lawyer could say that they were confused or they misunderstood the law?
I don't subscribe to Mr. Musio's position that attorneys that are members of this bar are misrepresenting to this court or any court what their reasoning was or what their position was. If Ms. Zanodakis indicates that she misinterpreted the law or wasn't aware of the 1-year statute of limitations, that's uncontroverted on the record. And to suggest that somehow her affidavit obviates that, I think is somewhat offensive to her.
Isn't the answer also, though, that unlike the normal case where a lawyer blows the statute in any case, in this case we have a specific statute, as in Section 10, that offers a remedy. I mean,
Precisely.
you know, it's not so.
Precisely, it's not the normal case where an attorney has not abided by a statute of limitations.
The statutory rescue doesn't exist in other circumstances.
No, I understand that. I mean, otherwise, we wouldn't be here. In Grabowski, we point. One of the things that we said was that the delay of the estate had not been prejudiced by this. Mr. Musio at least makes an argument here, and I think in his brief, that the delay really has prejudiced his clients.
Well, I don't believe that it's the type of prejudice that the court has previously considered in the context of these types of cases. The Mustafa's case, as well as the Mullins case, again, a federal court case, have indicated that under circumstances as here, where the estate is put on notice of the claim within the 1-year statute of limitations, that it's very difficult, if not impossible, to prove any claim of prejudice whatsoever. I think the prejudice relates to the notice of the claim. I mean, prejudgment interest, that applies in any case in which claims have been reinstated.
But couldn't you say, in this case, since this is a bill in equity, and it's really, the statute has, you know, if one goes this way, sort of given you a life rope, or whatever I'm trying to say, that perhaps equity demands that you not get in. I mean, assume you prevail on the underlying claim, or your clients do, that equity would demand that interest back to the date of death not be awarded.
That's an issue which we'll address when the time comes. I did not research that. My position obviously would be that we would be entitled to prejudgment interest, but that's something we would have to research.
Aren't you just looking for the property here? Is there something else you're looking for, cash in addition to the school?
Well, there are quantum merit claims, Your Honor. There are two claims. There are claims that
they're financial claims.
So there are claims that are certain equitable interest in the land.
And those claims have survived?
Those claims have survived.
So they're still pending?
They are still pending.
They didn't need 197 Section 10 to be revived?
The underlying court ruled that was not applicable.
How could your attorney believe that you were not creditors? She wrote, I believe, in her affidavit that she believed, but her filings in the probate court referred to you as creditors.
I couldn't speak for Ms. Zanodakis, Your Honor. I mean, the entire affidavit, I think, shows respectfully to her, and I'm not one to criticize another attorney, that she had no understanding of the statutory scheme.
Isn't that a reason that there are underlying facts here that couldn't be resolved by the single justice, because her affidavit, at least to me, is very confusing and contradictory?
Well, the standard of review here is abuse of discretion or clearly erroneous.
Is it really? This is a 197-10. Why is the standard that? Isn't this a decision for the whole court to make?
I don't dispute that Your Honors are entitled to find, well, actually, I do. I take that back. I don't think it's disputed that the standard here is abuse of discretion. That's the standard that was articulated by the appellants, which we adopted.
Well, they take a different stand. No, well, and that's not what they say in their brief. They say this is 197.10. This is specifically a decision that the Supreme Judicial Court is assigned to make.
In the statement of issues, they make reference to reversible error.
All right, well, in any event.
Reversible error by not ordering an evidentiary hearing and so on.
You agree that on the basis of this record, we as a court can make additional findings of fact.
Yes, but I would think that the decision of the single justice is to be accorded great weight, and it's our position that unless this court can find, based on your review of the facts in the record, that that finding was somehow clearly erroneous, that finding should stand.
Well, I may be wrong, but I read you as implicitly saying that the affidavit is contradictory within itself.
I don't adopt that. I mean, I don't dispute the fact that she says that
one thing and then says another thing.
Sure.
So then how can the single justice make findings?
Well, if the single justice concluded based on that affidavit that Ms. Zanoudakis didn't understand the applicable statute of limitations, didn't understand the statutory scheme that was in place, which is clear from that affidavit, he could then conclude from that and infer from that it was inadvertence or mistake that led to the failure to abide by the 1-year statute of limitations. That is what that affidavit is, I think, is a misunderstanding of the statutory scheme that controls this type of case.
Mr. Berman, let me ask you this if I can. It's here.
Oh, I'm sorry, Your Honor.
What is the status of the quantum merit claims?
They're pending. We are waiting a trial date.
I mean, nothing has been stayed.
Nothing has been stayed officially, Your Honor, but we have been going in periodically for status conferences pending the outcome of this case. Because there is a sister case that relates to the legal malpractice, which, if this court reinstates the underlying claims...
What is the sister case?
It's Gates and Russell versus...
So there's a third action?
There's this action,
right?
And then there's a legal malpractice claim which we filed because the statute of limitations was beginning.
And then where's the quantum merit? Where's the leftover piece of the?
That's also in this case.
Well, that's in the Superior Court.
Yes, Your Honor.
That's what I thought.
Is that a quantum merit? It's quantum merit? That's what it is?
There is a quantum merit action. There's a promissory estoppel claim, and there's a couple of other.
Is there a challenge?
When you say there's an equitable, your attempt to enforce an equitable interest in the school property, what kind of claim is that?
That would be an equitable claim.
Okay, so those are all pending, having nothing to do with 197.10. So it's not like there isn't a remedy here for you.
Well, there's a remedy, but in our view, it's a much less desirable remedy because in the context of equitable claims, the trier of fact would have to conclude that we're entitled to everything or nothing. There is no middle ground there.
Mr. Berman, let me put it this way. With what has survived in the Superior Court, that part that was not dismissed by the Superior Court judge on statute of limitations grounds, is there a challenge to the disposition of the school, of the property? I mean, is this an attempt by your clients to set aside the will?
Well, that is an action that has already taken place. They challenged the probate of the will. That was unsuccessful.
Unsuccessful by whom?
On our part.
By your clients.
Right. We weren't able to set aside the will. I was not involved at that point, but predecessor counsel was unable to have the will set aside.
And that's what the defendants are claiming, is that you waited to see what would happen in that suit before you began this suit.
That's speculation. There's nothing in the record to suggest that.
I'm trying to figure out, so that you've lost that. So how do you get access? And that's where the school was left to all of the nephews and nieces, correct?
Correct, Your Honor.
And what has happened? Is the executor just holding on, disposing of that?
There's an injunction in place.
There is an injunction in place which enjoins the sale or encumbrance of the property. The school is an ongoing entity. Beth and Kate are running the school. It's a profitable enterprise. This is their life work of 40 years, and they're going to continue to do it for as long as they possibly can.
If they prevail on their quantum Melwood claim, I'm going to call it quantum Melwood because it's for the work that they did, correct?
Yes, Your Honor.
In essence, that's their claim, right?
Yes, Your Honor.
And if they prevail, and have they sought relief that the school be transferred to them?
School on the land upon which it sits, Your Honor, and that's based on the promises that were made by their Aunt Mildred Doolin.
But what isn't... Wouldn't there be a statute of frauds problem there?
I'm sorry, Your Honor.
Well, two things. One, notwithstanding the conclusion of the probate court that this was that they couldn't set aside the will, correct?
Yes, and I think that was based on a claim of undue influence. This is something completely different. It's actually based on the fact that the will did not contain a provision which left them the school.
What is the basis, if they get a monetary judgment, what is the basis for having a conveyance of the property to them as opposed to having the property sold to pay whatever damages may be due to them?
But that's an issue that needs to be resolved. I think it depends on whether or not we're successful on the equity claims or on the...
And the equity claim is?
Claiming an equitable interest in the land based on the promises that were made.
Notwithstanding the fact that she changed her will and that will has been held to be valid.
Correct, yes. It's the fact
so that if I promised you, the theory, I'm just trying to understand the theory. If I own a school or building and I promise you that I will leave it to you, and then in my will I leave it to somebody else, and you try to set aside the will and the probate court rules against you, you nevertheless think that an equitable claim survives?
Yes, and I think if there's a section in our brief which sets forth a plethora of cases under exactly those circumstances where somebody provides a service in exchange for a promise to be included in a will, they're not included, and they're entitled to claims under equitable theories.
They may be entitled to monetary damages, right? They may not be entitled to the school.
Well, that's an issue that's somewhere down the road, Your Honor. I don't dispute that is an issue, and it may very well be that in the event that our claims are reinstated, we'll have to consider whether we want to continue with the equitable claims. I can't make a representation as to that at this point, but it would be cleaner, in my view, to have the underlying claims reinstated and go forward on that basis. I think the equitable claims were put in place in response to the dismissal, in response to the fact that they had not abided by the one-year statute of limitations. They were trying to be creative in maintaining the cause of action, and that's also part of the reason why my clients were lulled into a sense of security by predecessor counsel, because they were incorrectly advised that the equitable claims would protect their interests, which in fact they don't completely. It's more difficult to prove.
Thank you, Mr. Berman.
Thank you, Ron. I'm open. Thank you.